Hi, so this deals with the issue of the employer arguing just cause for termination under common law standards. Generally speaking, it's a difficult road to hoe for the employer to succeed in this argument. But here's a few of the general principles. In the next video, I'll give you some idea of specific examples. So generally speaking, the basic principle is the issue of just cause. The conduct has to go to the root of the employment relationship. It's got to be something serious, and it has to be looked at from the view of a reasonable employer. Not that employer, what that employer may think, but when a reasonable bystander would think is sufficient to amount to just cause. There's some general principles that have emerged. There's a Supreme Court of Canada case called McKinley, and McKinley dealt with an allegation of dishonesty by an employee, but it sets some general standards, and one of them is that the court has to look at the entire context of the conduct in question, and the employer should show it has considered alternatives as opposed to termination. Did it consider other avenues that could be addressed to deal with the apparent transgression? So for there to be termination for cause, it has to be proportional. That is, the termination, which is the most severe remedy an employer can impose, has to be proportional to the alleged offense. And the employer can succeed occasionally. I'll give you some examples, but those are the basic general principles. The employer, where serious cause allegations are made, should show it has done a proper and fair investigation. Well, that doesn't mean if they don't do an investigation, they can't argue just cause for termination. They can, and many cases have succeeded where the investigation has not been done properly, and the employer still has argued just cause for termination. When an investigation has been done, the report of the investigator is not admissible to prove what happened. It's only admissible to show, yeah, there is an investigation. And when there has been an investigation, then the employer, even though it may fail in the just cause allegation, will not be hit with additional damages of aggravated or punitive damages. So that's why most employers do it, just to avoid any claim, well, maybe to do the right thing as well, and to avoid any claim for aggravated damages. The employer can use conduct discovered after termination. So if the employer found that the employee was doing nasty things, it can argue post-discovered facts to argue termination for cause. A court generally will look at that with a certain degree of skepticism, but it can be done and can succeed. Any conduct that occurs post-termination is not grounds for termination. I actually had a case once where the employee pulled a knife, if you can believe it, on the employer. And the issue was did he pull the knife before he was fired or after he was fired? If he pulled it before he was fired, then there's just cause for termination. If he did it after, it's a nasty thing to do. It could lead to other claims, but it doesn't relate to termination of employment. Not necessarily a good position for him to be in either respect, but still, it shows the distinction. So just beware of all this.